We just caught the ATF trying to steamroll over a major court ruling and undermine our right to keep and bear arms. Once again, these geniuses attempted to classify millions of firearms as unlawful short-barreled rifles simply for having an accessory designed to help with stability. In this video, we'll talk about the ATF's recent maneuver, how gun owners of America forced them to backtrack, and what every proud supporter of the Second Amendment needs to know to stay ahead of any further government overreach. First, let's get right to the heart of the matter: stabilizing braces. For those who may not be familiar, a stabilizing brace is a firearm accessory originally intended to help shooters, particularly those with physical limitations, hold or fire an AR or similar platform more safely and effectively. Instead of resting on the shooter's shoulder as a rifle stock might, a stabilizing brace is strapped around or braced against the forearm. Many legitimate gun owners value these devices because they can make shooting more comfortable or more accurate, especially when dealing with a pistol configured on an AR-type platform. However, the ATF has had a long and confusing history with these accessories, frequently changing its determinations on whether installing them transforms a firearm into an unregistered short-barreled rifle, which is regulated under the NFA. Let's rewind a bit. On November 8, 2023, the United States District Court for the Northern District of Texas issued a ruling that stayed and effectively vacated the ATF's entire rule regarding stabilizing braces. This was a major victory for gun rights advocates because it stopped the ATF from enforcing its final rule that would have arbitrarily labeled many braced firearms as short-barreled rifles. Despite this clear ruling, the ATF hasn't exactly been enthusiastic about complying. In fact, their track record suggests they've been trying to push their agenda under the radar, hoping most gun owners won't notice until it's too late. Recently, a member of the Gun Owners of America reached out to the ATF's Firearms Industry Programs Branch, FIPB, to clarify whether installing a stabilizing brace on a pistol would require registration under the NFA. Under the established court order, which says the rule is stayed nationwide, you'd expect the ATF to simply say, "Because of the court order, we can't enforce our brace rule, so it's not currently required." However, that's not what happened. The ATF's initial email response essentially ignored the court ruling, telling the individual that any pistol with a brace attached needed to be registered as an SBR. In other words, the ATF made it sound like nothing had changed and that the vacated rule was still in full force. This response caused immediate concern among gun owners who had followed the court's decision and believed that the ATF was legally restrained from enforcing its rule. After all, if the rule was stayed and vacated by a federal judge, how could the ATF continue to act as if it was still valid? Furthermore, the email went beyond the original rule by not even bothering with so-called criteria for determining whether a brace constitutes a stock. It basically declared any braced pistol under 16 inches to be an unregistered short-barreled rifle, period. For many people, this felt like yet another example of the ATF overstepping its bounds and trying to legislate rather than enforce existing law. Remember, the Constitution doesn't give an agency the authority to create or redefine crimes at will. This is where Gun Owners of America stepped in. Eric Pratt, who leads GOA, sent a notice to the ATF, calling them out on their obvious contradiction of the court's ruling. He gave the agency a chance to explain, perhaps hoping it was a mistake made by an uninformed or overzealous staff member. After a few days of being ghosted, GOA sent another notice, this time not just to the individual who had responded with that questionable email, but also to the higher-ups at the agency. GOA explained that they would present this communication in court as evidence if the ATF refused to comply with the existing court order. It was a clear shot across the bow. "We're not backing down. You need to correct your stance in writing." Finally, the ATF caved. Late in the day, they responded to GOA, and while it wasn't exactly a heartfelt apology, it was a significant reversal. In the letter, signed by Matthew Scheer, the chief of the Firearms Industry Programs Branch, the ATF begrudgingly admitted that their previous statement, claiming that federal law requires a pistol with an attached stabilizing brace or stock to be registered as a short-barreled rifle, was overly broad. The letter also clarified that the ATF is, at least officially, abiding by the Northern District of Texas decision, meaning they can enforce their final rule on braces as long as the stay is in place. However, the letter did mention that the government is appealing the decision, which means we can expect more battles ahead. What does this mean for you, the responsible gun owner who cares about preserving the Second Amendment? Simply put, the ATF has been forced to back off for now, but that doesn't mean they've given up. The letter made sure to emphasize that the ATF is still charged with enforcing the statutory definition of a short-barreled rifle under the NFA. It also reminds everyone that just because the brace rule is stayed, it doesn't automatically allow any configuration that might otherwise qualify as an SBR under existing law. But here's the kicker. When it comes to stabilizing braces specifically, the ATF's own new rules are in limbo. They tried to bury that fact by issuing a misleading email to a GOA member, only to find out that GOA wasn't going to stand for it. We all know the importance of staying vigilant. The ATF won't stop testing the limits of what it can do. That's why we should support organizations like Gun Owners of America, the Second Amendment Foundation or ASAF, and the Firearms Policy Coalition. They're the ones holding federal agencies accountable, using the courts to push back when bureaucracies attempt to turn regulations into new laws. If you want these groups to keep winning, consider supporting them financially or by sharing their work with friends and family. And by the way, if this video was helpful in any way, please like, share, subscribe, and click on the bell icon for more of these videos. Thanks for watching. Now, it's worth looking at how we got here in the first place. The National Firearms Act was enacted in 1934 with the supposed purpose of curbing gangster violence, focusing on dangerous weapons like fully automatic machine guns, short-barreled shotguns, and short-barreled rifles. Over the decades, the definitions have been stretched, particularly when it comes to determining what constitutes a rifle designed or intended to be fired from the shoulder. As pistol-based platforms like the AR-15 gained popularity and stabilizing braces were developed to help people shoot pistols more comfortably, the ATF periodically changed its view on whether braced firearms were actually SBRs. That's part of what created this chaotic legal environment. Earlier this year, the ATF published a final rule that outlined complicated and often contradictory criteria for deciding whether a brace, in effect, transforms a pistol into an SBR. Gun owners across the country were left with uncertainty. Would a certain brand or configuration be allowed? Should they remove braces altogether to stay compliant? The biggest sticking point was that the ATF arbitrarily set these objective design features that frequently required guesswork to interpret. It put law-abiding citizens at risk of a felony charge simply for owning a product they had legally purchased. This shows why the Northern District of Texas ruling was such a landmark. It cut through the ATF's attempts to blur the lines and basically said, "Stop. This rule cannot be enforced while it's being challenged in court." But what's the broader takeaway? The ATF's behavior in sending that initial email to the GOA member reveals a stark truth. The agency either hoped no one would notice they were sidestepping the court, or they believed they could interpret the ruling in a way that still gave them free rein to label braced pistols as SBRs. Either scenario shows why constant vigilance is necessary. If GOA had not stepped in, how many other people would have received similarly misleading or downright incorrect information from the ATF? How many would have felt compelled to register their braced pistols or even dismantle them out of fear? A major lesson here is that we, as gun owners, do not and should not ask permission for our rights. The Second Amendment says, "shall not be infringed." It doesn't say, "shall not be infringed unless the ATF decides otherwise." While it's understandable why some folks might reach out to the ATF for clarification, after all, the last thing anyone wants is a felony charge. The best approach is usually to consult an attorney well-versed in firearm law or contact Pro 2A groups that have a deep understanding of these regulations. The ATF's track record shows it isn't always a reliable source, especially when it's trying to push an agenda. Speaking of agendas, we must remain alert for future legislative and regulatory battles. Several bills in Congress aim to protect our gun rights, such as those that would enforce nationwide reciprocity or allow individuals in constitutional carry states to exercise that freedom across state lines. However, some of these measures still operate within the framework of permits and restrictions, which many argue are infringements in themselves. The essential message is that while these bills might offer incremental relief for those stuck in less friendly states, the ultimate goal should be an unambiguous respect for our God-given rights. The ATF's flip-flop on the brace issue, forced by GOA's direct challenge, is a good reminder that no matter who is in the White House or which party controls Congress, the bureaucracy can and will try to enact gun control through regulation if they think they can get away with it. We saw it with the bump stock ban, and we're seeing it now with pistol braces. Court victories are great, but they don't end the fight. The ATF has already appealed the Northern District of Texas ruling, meaning the question of whether the final rule on braces becomes permanently dismantled will likely depend on higher courts. And even then, the ATF could attempt to rewrite the rule, tweak a few definitions, and start the process all over again. Staying informed is our greatest weapon. When these agencies try to bend or break the rules, it's the vigilance of grassroots organizations and everyday people spreading the word that stops them in their tracks. If GOA hadn't brought the ATF's rogue email to light, we might not even be having this conversation. There's power in numbers, and if we collectively push back, agencies cannot ignore us. That's why I always encourage folks to not only join groups like GOA, the Second Amendment Foundation, and Firearms Policy Coalition, but also to share updates on social media, call or write your representatives, and make your voice heard at the local level. Ultimately, the ATF's attitude of "we can still enforce other aspects of the NFA" is a thinly veiled warning shot. They want you to know that while the new rule is tied up in court, they are still looking for ways to regulate short-barreled rifles or anything that resembles them. This kind of environment creates a chilling effect, making law-abiding citizens uncertain about what they can and can't do with their firearms. It's exactly the reason we must continue to support legal challenges against this overreach. And it's also why you should keep contacting your elected officials, reminding them that your Second Amendment rights are not negotiable, not subject to bureaucratic whim, and certainly not up for constant reinterpretation by an unaccountable agency. There's no telling what might come next. Some in Washington are desperate to curtail gun ownership through new laws or expansions of the NFA. They may push for more red flag laws, universal background checks, or attempts to ban so-called assault weapons. But remember, even the standard AR-15 is frequently misrepresented as an assault weapon, so these proposed bans often affect a wide range of common, legally owned firearms. The more we push back at every turn, the more we make it clear that law-abiding citizens are not the enemy, and that these infringements run contrary to both the letter and spirit of the Constitution. As we approach potential leadership changes or legislative shifts, always remember that no politician or bureaucrat has the authority to strip away your fundamental rights. It may be challenging, especially in states with restrictive laws, but collective grassroots action has a proven track record of success. Look at how quickly the ATF had to reverse course when GOA pressed them. That was a matter of days, not months. The key is to keep shining a light on these attempts to undermine the Second Amendment and to continue supporting the legal battles that force the government to abide by the Constitution. If you've stayed with me this long, you're clearly someone who cares about your 2A rights, and that's exactly the kind of person our community needs. Someone willing to stay informed and help others learn the truth. If you found this breakdown of the ATF's latest backpedaling and the GOA's successful challenge helpful in any way, please like, share, subscribe, and click on the bell icon for more of these videos. Thanks for watching.